and the plaintiff is fool enough to believe that story and buy the Cadillac and then find out later that Abraham Lincoln died decades before automobiles were even invented, and the plaintiff sues me for misrepresentation, the chances are the plaintiff is going to lose, because the reasonable person would probably not have believed that story I told, and so the plaintiff was not justified in believing it. Incidentally, there are some statements that salespeople make that nobody in his right mind would ever believe. Those statements, those exaggerated sales statements that say things like, "This is the greatest car on the road. You are going to love this car. This car is a sweet job. This car is a Bearcat. This is a comfortable car. This is a groovy car. This car is going to get you a lot of dates. This car..." Those statements which we regard as puffing, natural exaggerations that salespeople make that are clearly statements of opinion, these are statements that usually do not lead to misrepresentation liability. Most torts case books are filled with cases involving puffing or puff talk or puff statements, and sometimes I think the only reason for that is because those cases are so amusing. It seems to me that it should be obvious to anybody that really understands what justified reliance means that a plaintiff is not justified in relying on those puffed up statements that salesmen so often make. Statements that a judge once said are like the promises made by a politician on the eve of election. Nobody really believes them, but everybody would be disappointed if they weren't made. The fourth element in a misrepresentation case is damage. And of course, if the plaintiff does not sustain a loss as a proximate result of the misrepresentation or of the plaintiff's reliance on the misrepresentation, then there is no liability for misrepresentation. Now, damage in a misrepresentation case can be measured in two different ways. Some jurisdictions measure damage by using the benefit of the bargain approach. The benefit of the bargain approach is based on the belief that the plaintiff is entitled to get what the defendant told the plaintiff would be getting. So, benefit of the bargain damages consist of the difference between the value the thing would have had if what the defendant said about it was true and the value it actually had. If the defendant tells me this is a bar of gold, and by the way, a bar of gold that weighed as much as this would cost $1,000, and all the defendant gave me was a bar of some other metal that's only worth $100, my benefit of the bargain damage are $900, because the defendant said I was getting something worth $1,000, I got something worth only $100, and I'm entitled to the benefit of the bargain. I'm entitled to the difference. On the other hand, there are some jurisdictions which apply the out-of-pocket approach to measuring damage in misrepresentation cases, and that's based on the philosophy that all the plaintiff really ought to get is what he started with. He should not be better off because of the misrepresentation than he would have been without it. If the defendant sells me this bar of metal saying that it's gold and gold would be worth $1,000, and I give the defendant $100 for it, and the defendant gives me a bar of gold that really is worth $100, I've lost nothing. Even though I hoped I was going to get gold, I really lost nothing under the out-of-pocket approach, and I would have no damage at all. Those are the four elements of misrepresentation. And of all the torts based on interference with economic advantage, misrepresentation is probably the most important. But there are two others that we also need to discuss: interference with contract and interference with prospective business advantage. The elements of interference with contract are intent, interference with plaintiff's contract rights. Intent means that the defendant desired or knew that the plaintiff was involved in a contract and that what the defendant did would somehow make the plaintiff's contract rights less, would make the plaintiff receive less of a benefit from the contract. Interference means that the defendant did something which made the plaintiff's contract right less valuable. And of course, the third element is that there must have been a contract right to begin with. Remember that our law is real careful about protecting contract rights because that's really the essence of a business-oriented society. So, if I know that you're involved in a contract, and I know that what I'm about to do will reduce the value of that contract for you, and I go ahead and do it, and it does reduce the value of that contract for you, I am liable for interference with contract. That's to be contrasted with interference with prospective business advantage. If you have a hope of making a profit, but that hope hasn't reached the contract stage yet, the law encourages me to compete with you. And so, I have not committed a tort against you unless I act with malice. The elements of interference with prospective business advantage are just like the elements of interference with contract, except that in addition to interfering with your hope of making a profit, which isn't necessarily reduced to contract stage, you must also show that I acted with malice. And malice means that I acted for some purpose other than my own business interest. So interference with prospective business advantage can be stated in terms of these elements.